surrounding the shooting in this case. The defendant directed the co-defendant in this case to shoot at the intended victim, Tamar Bagley. According to witnesses, the state intended to call at trial in this matter. The motivation behind that was to eliminate the victim as competition in a drug trade. They both were selling illicit drugs at the time of this offense.
Slushy.
Thank you, Your Honor. We are present in State of Ohio versus Joshua Transu on 2 cases to an amended lesser included offense of count 2, attempted felonious assault, a felony of the 3rd degree with the attached 3-year firearm specification, and count 3, having weapons while under disability, a felony of the 3rd degree. And in case 25 CR 1708, the defendant pled guilty to counts 1 and 2, being trafficking in a fentanyl-related compound, a felony of the 4th degree. And the court referred the ordered a victim impact statement to be completed prior to today's sentencing. The state is prepared to proceed with sentencing.
The family would like to say something on his behalf, and they've elected one representative, Tia Cruz, to speak on his behalf.
Would you like to have her speak now?
Yes.
Your Honor, my name is Tia, and I just wanted to speak on behalf of Josh. I know poor decisions were made, and I'm not here to excuse them. I only want to speak about the person I know behind the situation. Josh was one of the most genuine and funny and giving and caring people I've ever met. He has a big personality, and it brings light into rooms, and he makes everyone around him feel comfortable and loved. He's the kind of person who jokes around and makes kids laugh, and he tries to make people smile, even when he's struggling himself. I truly believe he is someone who never had the right guidance or environment growing up. A lot of people are shaped by the people around them, and unfortunately he spent a lot of time around the wrong influences and made choices that brought him here today. But I do not believe those choices define who he is at his core. What stands out to me the most is how much his children love him and need him. I believe he has a lot of potential that has not fully had the chance to develop in the right direction. He's not beyond saving, and he is not beyond change. I respectfully ask the court to consider not only his mistakes, but also the person he's capable of becoming, and the people who love him, and his other children who need him as well in their lives. And thank you for your time.
Thank you, Tim.
Buckle up, guys. Today, we are going to break down a courtroom case where a man stands before a judge facing serious felony charges that could change his life forever. Before the legal arguments begin, someone close to him speaks from a heart, describing him as a caring father, loyal friend, and someone capable of becoming a better person despite the poor choices that brought him to court. The hearing opens with hope, but everyone knows the facts behind the case will soon be tested.
Mr. Deeb.
Your Honor. Thank you, Tia. Your Honor, when he's in his element with his family, he is respectable. He's someone they can rely on, and everybody says positive things about him. However, he's put himself in situations, he maintains friendships and certain activities that obviously put him at risk, and that put him in this situation today. Originally, in speaking with Mr. Transu, knowing that the time involved and whatnot, he was emotional and didn't want to accept the writing on the wall. But as we talked more and more and we went through the discovery, the pros and cons of the case, he was more rational and more accepting of everything. And he did accept responsibility, and we do have the agreement. We asked the court to go along with that agreement. He is dejected, but that's only because he sees that he's put himself in a situation where he has taken himself at a minimum 10 years away from his family. What we asked the court to do is tailor the sentence so that it would be a 3-year gun spec with a 2-year sentence on the attempted felonious assault and 3 years on the weapons without disability or under disability. It gives him the incentive to try and better himself. When I talk to him, we talk about his environment and how he puts himself in these positions, and it's the friendships he maintains, and he doesn't have many adaptable skills to work at. He's had jobs and he's worked, but he hasn't been able to support his extensive family because he has several kids. But he's going to take advantage. We talked about the programs in prison, the CDL program, Ashland University, and that's what we focused on, and he's looking forward to getting in there and making himself more valuable in the work community so he can live a law-abiding life. because all he knows is to go back to some of his old behaviors, and he's committed to change. And the length of time that we are talking about here will give him that time to accomplish a lot of those goals and to come out a better person. Thank you, Your Honor.
So how are you requesting, and I know there's an agreed total sentence, but there's no agreement on how it's broken down, right?
That's correct.
So what is your request?
2 years on the attempted felonious assault, and I was unable to find any case law to say that that would be not mandatory. And 3 years on the weapons under disability, so it would be 3, 2, 3, for a total of 8.
Is there anything you'd like to say at this time?
Yeah.
Okay.
I would like to say a few things. First of all, I want to start by saying I apologize to the victim and the victim's family for who I may have hurted in the process of what happened. And I will forever be apologetic for what happened. And whatever sins I get here today, I deserve. And I will take that time to go down there and better myself and be a better person for society, my family, and my unborn daughter. Thank you.
Thank you. Mr. Deeb, is there anything else that you want the court to consider?
No, Your Honor, not this time.
The defense now shifts the focus to responsibility and redemption. The attorney explains that the defendant has accepted the reality of his situation and wants to use his time to improve himself instead of wasting another opportunity. When the defendant finally addresses the court, he apologizes directly to the victim and family, admits he deserves whatever consequences follow, and promises to return as a better father, better citizen, and better person. His words add emotion just before prosecutors reveal what actually happened.
All right, then I'll hear from Ms. Alessi first in regards to the, I don't know if you're speaking for both, or you're both going to?
I'm just going to speak for both.
All right, then for the state of Ohio in both cases.
Thank you, Your Honor. The state would ask the court to adopt the jointly recommended sentence of 10 years, 8 years on case 1536, and the 2 years on case 1708 consecutive to the 8-year sentence. The state would defer to the court as to the breakdown of the 8-year sentence. I know there was not a pre-sentence report in this case, so I think it's important for the court to know and understand the circumstances surrounding the shooting in this case. The defendant directed the co-defendant in this case to shoot at the intended victim, Tamar Badley. According to witnesses, the state intended to call at trial in this matter. The motivation behind that was to eliminate the victim as competition in a drug trade. They both were selling illicit drugs at the time of this offense. Although the victim was not physically injured in this, the outcome was sheer luck and to no credit of the defendant. The defendant ordered the co-defendant to wipe him down or walk him down, meaning to kill Tamar Badley. I think what makes this offense even more troubling is the setting and the relationship between the parties. At the time that the shooting occurred, the victim was not a stranger to the defendant. The victim's family at one point considered the defendant an extension of their family. They were someone he knew. They knew that they trusted. The house where the shooting occurred is actually an address where the defendant listed as his home address at one point. At the time of the shooting, there was numerous people outside on the front porch that was in the direction of where Tamar Badley was standing. In fact, they would have been behind where the victim was standing and where the co-defendant was ordered to shoot. Although the defendant was not physically holding the gun at the time of the shooting, the defendant drove the co-defendant there. He began the verbal altercation with the victim. He ordered the co-defendant to shoot. After the shooting, he fled. He hid the firearm. And the state believes, and even the family believes, that if not for the defendant, this shooting wouldn't have even have happened. The co-defendant did not know anyone at the residence. He did not know the victim. In fact, if the co-defendant had not been shot and injured himself here, it is possible that the state may never have even identified him because he was so unknown to the people at the residence at the time.
This is where the case takes a dramatic turn. Prosecutors describe an alleged plan far more serious than many expected, claiming the defendant directed another person to shoot a rival during a dispute connected to illegal drug activity. They explain that innocent people were standing nearby and that the outcome could have been far worse. According to the state, the defendant was the driving force behind the violence, making this much more than an ordinary criminal case.
The defendant has a lengthy criminal record. He has juvenile adjudications for burglary, a felony of the 3rd degree, trafficking in marijuana, a felony of the 5th degree, and robbery, a felony of the 3rd degree. He also has 3 prior prison numbers. In 2015, he was sent for 14 months on a carrying concealed weapon charge, a felony of the 4th degree. In 2017, sale of counterfeit drugs, a felony of the 5th degree. Again, in 2018, out of Ashtabula County, trafficking F3 and trafficking F4. According to Oleg and prior prison records, the defendant is a known heartless felon gang member. Or not necessarily, he was not on bond in our case, but he committed the trafficking offenses and the other case before the court today, and the defendant has the pending charge of felonious assault in Cuyahoga County that occurred in October of 2025. There's been no conviction in that case. Like I said, there's no conviction, but I think it's worth noting that the defendant has continued to engage in the drug trade and commit offenses of violence.
When were the drug cases committed?
March of 25.
And the Cuyahoga case was later that year?
Yes.
Okay.
So the state would ask you to impose the jointly recommended sentence of 10 years. In regards to jail time credit, on the drug case, the defendant has 4 days, and on the attempted felonious assault, the defendant has 61 days.
Does the 4 days on the drug case...
After explaining the shooting allegations, the prosecution strengthens its argument by reviewing the defendant's lengthy criminal history. The court hears about previous prison terms, juvenile offenses, continued involvement in drug crimes, and additional pending violent charges. Prosecutors argue that repeated opportunities have failed to change his behavior, painting the picture of someone who continues returning to crime despite multiple chances to rebuild his life.
Overlap at all with the
No.
felonious?
No.
So they're separate?
Yes.
As for recidivism factors in both cases, the court finds the defendant has an extensive history of juvenile delinquency adjudications as well as convictions as an adult. He has served multiple prison terms before. He has not responded favorably to previously imposed sanctions, violated his bond and failing to appear. No factors indicate recidivism is less likely. The court will impose a prison term on the lesser included offense of count 2, attempted felonious assault, of 2 years in prison. I guess it'd be 24 months in prison. That is to be preceded by and consecutive to a mandatory term of 3 years for the firearm specification. The 2 years is also a mandatory term in as much as their gun specification is attached to that count. On count 3, it's a sentence of the court. Defendant serve a term in prison of 36 months. In this case, I need to advise you upon your release, you will be placed on post-release control. In case 25 CR 1708, it's a sentence of the court that in both counts 1 and 2, defendant serve a term in prison on each count of 12 months. Those 2 counts will be ordered to be served consecutive to each other for an overall period of 2 years. And that 2-year term will be ordered to be consecutive to this term just imposed, 8-year prison term imposed in 25 CR 1536. In this case, post-release control is not mandatory. I think that covers everything. Is there anything I omitted, Ms. Alessi, that needs to be addressed?
I don't believe so, Your Honor. Thank you.
Mr. D for the defense?
No, Your Honor.
All right, good luck, Mr.
With every argument now on the record, the judge delivers the court's final decision after reviewing the defendant's criminal history, prior sanctions, and the seriousness of both cases. The sentence reflects the court's belief that repeated offending and escalating violence requires significant consequences. The hearing concludes as the judge explains the final orders and brings the case to a close. If you found this courtroom breakdown informative, make sure to like this video, subscribe to the channel, and we'll see you in the next video.